The burden is on the plaintiff to show he wasn't trespassing.
Why is Mr. Studer not a trespasser?
Dawn and Diane, Ms. Petrius and Ms. Hayes, both indicate they wanted him there. Dawn indicates, yes, I asked him to be there.
Why on God's green earth is Mr. Studer standing upon the landscape box?
He's documenting the obstruction of the path.
You can't do that from the ground? Why is he out there at all? The fact that Mr. Hines had a past zoning issue does not answer my question. What right did he have to be on that person's private property? All right, let's call next Studer v. Hines, file 24-9075NO. Being back on our civil docket, we are providing public access not only in the courtroom, but also online. And counsel, you want to state your appearances, beginning with plaintiff.
Judge Mike Flagstead, P number 79314 on behalf of Mr. Studer.
Good morning, Your Honor. I'm Jack Deegan. I'm on behalf of the defendant. My P number is.
Oh, I don't require that sort of thing. Yeah.
He said it, so I want
to. That's fine. You wanted to say you had an earlier one or a later one?
Yeah, no, strike that. Yeah. You got me by 20,000.
All right. Thank you very much. All right, this is defense motion for summary disposition. And before we get into the merits of that, there was a brief, a response, a reply, and then a supplemental brief filed by the plaintiff. And Mr. Deegan, you have objected to that supplemental brief. You want to say anything about that objection?
I do briefly, and I don't normally file objections like that, but this is an important motion to me, and I do believe that their supplemental filing doesn't follow the court rules. Generally under 2119, I file a motion, they file a response, and then I get 5 pages to reply. Within their response to my motion for summary was arguments as to the work comp lien and also what it looked like a motion in limine, and then a couple paragraphs as to I-2. A lot going on there, 2.116 I-2, but I kept my response within 5 pages. So I was very surprised then when I got another supplemental response. And I did object. I can find no basis for that under the court rules. And so I filed that objection to preserve the record. That is the purpose of my objection, Your Honor.
Okay, thank you. Mr. Flagstead, what's your response to that?
Judge, I hope the court received my response, my written response to Mr. Deegan's objection. If it didn't, I'd be happy to.
I did. Yeah.
Okay. Judge, I do believe 2.116 G1A is the correct part of the court rules. And what G1A indicates is that when a party files a motion, it gets a brief, the non-moving or responding party gets a response, and the filing party gets a reply. And Judge, I would indicate that's exactly what we did.
Yeah, except you didn't. You didn't file a motion. You filed a response to a motion, and in that response, you asked for partial summary disposition in your favor under what, I-2, where if it appears to the court that the opposing party rather than the moving party is entitled to judgment, the court may render judgment in favor of the opposing party. So it's perfectly appropriate for you to ask for that remedy, which you did. That doesn't make it a separately filed and noticed motion, does it?
I would agree, Judge.
So you didn't file a motion.
We did style our motion in brief, a counter motion in brief.
Right, by skipping the notice of hearing.
We found notice of hearing.
Skipping the notice of hearing timing requirements, skipping the filing fee. I mean, you're filing a response and saying my response is not only a response, but like 2 other motions, but I'm not going to file them as separate motions. That doesn't seem consistent with the court rules at all.
Well, I'm sorry, Judge. I'm jumping at the bit and I'm interrupting you.
No, go ahead. And so I'm just wondering, then it looks like you're asking for here's an old-fashioned word for you, a surreply. There's a motion, a response, a reply, and then sometimes if the court allows it, a surreply. But that seems to be what you were doing. Explain to me why I'm wrong about that.
Judge, we did file a notice of hearing with this time and date. It did comply with the notice requirements. I believe it was 24 days prior to today's date. We did submit a check, Your Honor, for a separately filed motion. There was a filing fee. We consulted with the clerk whether they would like an additional filing fee for the counter motion. I believe the answer was no. And furthermore, Judge, as we indicated on the face of that counter motion, if this action does not please the court, we would be more than happy to back off from that, separate out our motions, or have it heard another day, Judge. Certainly it's at your honor's convenience. If it is not convenient for your honor, we would be happy to separate that out. Our thought process, Judge, was kind of twofold. The 2116 subpart, which I can't cite off the top of my head, does seem to encourage consolidation of motions. And moreover, your honor, we'd be looking at essentially 3 motions and briefs across 2 separate days on the exact same facts and issues. That was plaintiff's thought process. If it does not please the court, if it is not convenient to hear our motions, we would be more than happy to separate those out to a different day, Judge.
Your response, Mr. Deegan?
Briefly, this is a simple process. This is the first time I've dealt with this kind of strategy and trying to get around the page allotments. And what I do believe is an attempt to make this confusing and try to indicate there's some issue of fact, which I'm going to argue there is not in my motion for summary disposition. What I heard was, okay, you got all this stuff in front of you now, but now I'll have a separate motion for partial summary disposition, a separate motion in limine. And that's not appropriate. What we're here for today is to argue my motion for summary disposition. They did say in 2 paragraphs, and I'm going to argue without basis, that somehow they get dispositive motion under I-2. The fact of the matter is we have a bunch of paperwork. I hate filing objections, but I had to protect the record. There is no court rule that allows this type of procedural play. I think my objections stand or should be granted.
All right, thank you. Well, as a matter of the court rules, the defendant, I think, is absolutely correct. The plaintiff, in the response to defendant's summary disposition motion, could argue that they're instead entitled to summary disposition under I-2, but this doesn't trigger the option to file a SIR reply. To the extent that plaintiff's motion was styled as a separate motion of some sort, it wasn't filed as such. That practice did not comply with the court rules. Defendant's reply was the final brief on the only pending motion, the motion for summary disposition under 2.116 G1A, and no supplemental briefs may be filed without leave of the court under G1A4. Having said all that, I mean, I read it, and courts can disregard stuff that I strike, of course. But also, I guess I'll say, I don't recall if we've had a case, Mr. Klagstead. I'm not remembering it. So this, I'm taking as Mr. Klagstead's first appearance in a civil matter with me. And there are some areas where the court rule doesn't, cleanly address some issues. What I would prefer, Mr. Klagstead, you do when you've got questions like that is see if you can get opposing counsel on the horn. And I'm very amenable to phone conferences with folks to sort out issues like that. What does not please me is then when stuff is just filed and then there's a footnote dropped for me to let you know if you should do something different. I mean, how courts work is when you file stuff, I try very hard to be a judge who's prepared for court, which means I'm reading them in advance of court. But usually that's not a matter of several weeks before the motion hearing.
Understood.
So I'm reading this footnote at the same time I'm reading Mr. Deegan's objection to what you've done. So that sort of approach doesn't really give us time to sort that out. So because I'm going to give some grace and not strike the brief, but let Mr. Klagstead know. I think Mr. Deegan's absolutely right about those court rules. And in the future, follow those. Or if you want to do something different, pick up the phone and we'll talk. Okay.
I'm satisfied. Thank you.
Okay, very good. All right. So, and you can have a seat if you want. You don't have to stand the whole time, and I let you argue from the podium or from the table, seated, standing, whatever you want to do. Mr. Deegan, go ahead.
Yes, Your Honor. And this is my motion for summary disposition. First of all, I do have a C8 aspect of the motion, and I won't go into great detail.
That's as to the count 2 negligence.
Yes, sir.
Which it seems to me would only survive if Mr. Klagstead was pointing out, hey, gee, you've raised a question about where this might have happened. And if it happened on the public area because of some improvement your guy put there,
possibly,
then that would be a valid negligence count. But it doesn't seem like anybody's claiming that's actually what happened.
No, and I cited some of the case law that would discuss that. For instance, if I had a piece of property near an alley, and then something was flowing into that I caused. And then I do agree, but there has been no allegation of that sort. So I do request that count 2 be dismissed.
Or if your client had placed landscaping stones in the public beach area, the plaintiff accessed the public beach area and somehow was injured by the placement of those landscaping rocks, that could be a negligence claim.
There has been, that's possibly, that would, your hypothetical may make sense. However, there is no evidence that any of the landscaping rocks were put on public right away.
All right. It sounds like the plaintiff is maintaining that although some folks may have had unclear understanding or recollection about ownership or lines, that the plaintiff's claim depends upon the fact that this happened within the easement.
It would, because with no evidence demonstrating that we breached any duty or even affected the public land, there is no argument as to a potential negligence claim.
Okay, and I know you pointed out some of those discrepancies about the location, just if it helps both parties to understand. I looked at all that and thought, there doesn't seem to me that those discrepancies rise to the issue of a genuine issue of material fact about the location. And I'm analyzing this as if the injury occurred on the servient estate of the easement, within the easement.
That is my understanding, Your Honor. And when you speak to issue of fact, that goes to C10 and has to count 1. And in this case, and you look at the case law, the burden is on them to show that he was not a trespasser. That is my allegation. This is an easement that has been in place a long time. The grantor of the easement is a lady named Diane Hayes. Her daughter is Dawn Bodner. The easement is simply for ingress and egress to the beach. That is it. Diane Hayes testified she never gave permission to, or authorized or asked Mr. Studer to come on premise. Her daughter also said, I never gave permission. My client certainly did. And then I have communication from counsel for the county that says he was not authorized to do this as a planner. With that being the case, this is a clear case of a trespass and an injury that occurred. My client never had any notice, certainly didn't have any idea. And understand that the rocks at issue here had been placed about a year prior. And they were for purposes of erosion. They weren't to prohibit anybody. You could still have access. So all the testimony is very clear that Mr. Studer, for some reason, found it appropriate to come onto this easement, which he is not a party of, and he found himself hurt, and now he sues my client. And that's inappropriate. Let's take it a bit further. If it's a trespasser, they have to show that we willfully or wantonly injured him. And
there's no indication of that.
There is none. If he's a licensee, we have to show that we knew of something that was dangerous, and we didn't take any care, but the duty there is quite limited too, as the court knows. And so with that being said, even if he is a licensee somehow, which I can't see, there's no issue of fact as to whether he's possibly a trespasser, let alone licensee. And I think it's been admitted that he's certainly not an invitee. Going forward, so there's no issue of fact. And the cases I've cited show that it is there in Tripp versus Baker, Allstar versus Glidden. Tripp versus Baker, the court says, where plaintiff failed to produce evidence creating an issue of fact on the point of a trespass, their case fails. There's another problem too, is just— Mr.
Deegan, I got a couple of questions for you.
Yes, sir.
What about I want to go back just a moment to the licensee issue and your argument, and it's in the briefs, that if the plaintiff is a licensee, your clients should still win because they had no notice of this defect, this hole.
And
that would normally, and you and I have had some cases that turn on that precise question.
We sure have.
And I know there's some merit to that as a general proposition. But in this case, it sounds like the facts are that the depression would be as a result of work that your clients did, putting that in, by putting in the soil and the sod, and then it settles and there's the hole. So do those general notice rules apply when the defect on the land is a result of actions that the landowner took?
I hear your honor, and that is complete speculation in this case, because the next point I was going to get to, let me go back to licensee. First of all, a landowner owes a licensee only a duty to warn of hidden dangers known or with reason to be known by the owner if the licensee does not know or have reason to know.
Sure, so that gets to the, would they have reason to know if it was
Correct.
caused by their actions?
And now, that's why I had indicated to the court that these landscape rocks had been in place for a while. No one had ever said they had a problem. We had no reason. Nobody said, hey, it's weird out there. And understand too, he stepped on the rocks and stepped off. But we've never had any indication. My client has used this. Diane Hayes, who is the grantor, and her daughter, they have never indicated that there was a problem. And the other issue too is you go to not only notice, but they don't even seem to know what exactly caused. He stepped off, maybe it was soft, maybe there was a hole. There seems to be speculation as to even what caused. Could it have been just simply stepping wrong? Happened to my neighbor last week, broke her foot. I don't know.
Well, and as to the notice, this is more a question for Mr. Flagstad, but it seems to me like, how would you have notice of that? Like, you wouldn't expect people are just going to be walking on top of the landscaping rocks. I mean, they're there for decorative purposes, not for a walkway.
They are, Your Honor. And so I think in this case is a bit unusual than the other ones I've had in front of you in other courts. It's pretty rare that you get a situation with a trespass that we argue, and normally you have an invitee situation.
Sure. Now, if he'd been there with Miss Hayes, he wouldn't be a trespasser, right?
Well, that's still debatable, because I think that having this individual come on for an investigative purpose, though not authorized by the county, I would have trouble agreeing with an argument that he was an invitee.
That's an interesting question to me, and I wonder, I'm thinking back to my days as a private practitioner, which might have been a few years ago. I remember going to various clients' premises when there were disputes about their property. As an attorney, I remember walking with clients on easement areas, and I guess I didn't believe that I was trespassing when I did so for my client to show me this is what's going on here, so that I could finish my investigation for purposes of filing a claim. So if Ms. Hayes was there with her lawyer, would that be a trespass?
I think if she was there with the lawyer, they would need to give notice. Hey, I'm coming on the easement with the lawyer, or I'm coming out with a public official. If you as an attorney judge had gone out to property to investigate with the client, I think you would have to give notice. And that's something I argued. You know, we didn't even get notice that they were doing this investigation. I think it's kind of outside of the realm of what we're dealing with today. But however, if and first of all, Miss Hayes, who has the easement, didn't even call him. So your hypothetical is interesting to me. It's an intellectual debate, but that didn't happen. She didn't even contact him, nor did the daughter. And so we're still trying to figure out why he was even out there. And so I have trouble with any type of investigation going on. But I think that would, at best, maybe, because you wouldn't have the invite, it would maybe be a licensee issue as opposed to, but definitely not an invitee. But the burden is on the plaintiff in these cases to show he wasn't trespassing. And they've got nothing. We've taken a lot of depositions in this case, and no one has ever said he had permission, he could do this. And he also exceeded the scope of the easement, which is simply for ingress and egress, not for investigation purposes. And that's why I took care to speak to counsel for the county to say, hey, has this been authorized? And the response said, no, he was not. he was not in the scope of employment, and it was pointed out specifically in the letter that actually there would be no reason to be there. The site plan, the zoning, everything had been taken care of. There are no issues pending on this property. So an
Yeah,
investigation.
there's no zoning issues present on the property. And are you aware of any provision of the zoning ordinance that would be implicated by a servient estate owner's interference with the dominant estate owner's easement rights in a private easement?
I am not, Your Honor,
Neither am I.
but I am not aware of any allegation that we have. There's been no formal filing. There's been no lawsuit or.
Right, but even if there were, that's a matter of a private property suit.
It's
not
a
zoning.
private property situation, and in this situation, for some reason, he wanted to come out and look at it. I don't know why, but at his own peril. And so I think that there are no facts that support keeping this claim alive.
All right, thank you.
You're welcome.
All right, Mr. Flagstaff, your response.
Might I remain seated, Your Honor?
Yes, that's fine.
Thank you, Judge. The first point, Judge, I bring it up because I'm surprised to hear defense counsel say it today, that there's no argument that the accident occurred in the public beach area. To the contrary, Judge, on page 7 of my response brief, I cited exactly where defendant has said that. And I only cited it the one time in their initial disclosures because I didn't expect it to be a contested issue. I believe they actually raised it as a defense. Furthermore, Judge, and Mr.
Right now, but I mean, I looked at all of that and there's lots of interesting stuff at the edges, but really you're saying this happened in the easement area.
My belief when we filed the suit was that the hole was in the easement area.
Yeah, and I think it was. I mean, there doesn't seem to be a genuine issue of material fact about that. And that's I mean, would you agree with that?
I would agree with you that that's the central thrust of an ordinary negligence claim. Yes, I think you've correctly identified.
So that would mean that count 2 should probably be dismissed on a C8.
Other than the fact that when he's deposed, Mr. Heinz insists it certainly was on public beach. And Mr. Harris points out to him at the time of the deposition, "Are you sure this is the route you want to take? I mean, you think this helps you?" "Oh, for sure. It was on the public beach area." And Judge, if they want to create that issue of fact, I think let them lie in the bed, take it to a jury and let a jury decide that that's not true. Candidly, Judge, I would rather a jury see that exchange and test that truthfulness for themselves.
Okay, well, I mean, I'm not interested in leaving counts alive just for the jury to play around
Understood,
with. So I mean, I'm almost certainly granting C8 on count 2. I'm much more interested in count 1. Why is Mr. Studer not a trespasser on the Heinz's property?
A number of factors, Judge. First of all, again, responding to Mr. Deegan, he said there's no testimony that anyone invited him. That's just not true. Dawn and Diane, Ms. Petrius and Ms. Hayes, both indicate they wanted him there. Dawn indicates, yes, I asked him to be there. Ms. Petrius further says, now I admit, Judge, this is a factual difference between the two depositions. Ms. Petrius says, yes, my mom knew I was asking him to be there. Ms. Hayes said, it's good that he was there. I would want him to be there. He was doing the right thing. Now, admittedly, Judge, she indicates that she did not call him. However, Judge, the testimony is that she set up a survey that morning, asked her daughter to march down there because she was in Florida and document the survey because she had a feeling those stakes would not remain.
Do you think that easement would allow Ms. Hayes to bring guests?
I do, Judge.
Right.
And Judge, it's an interesting point that you raise for a couple of reasons. Defendants spent 2 pages of law trying to convince the court to narrowly construe the easement, and at least 3 different arguments that hinge on how they say the court should interpret the easement, but they've only pulled 2 sentences from the easement itself. If you actually read the easement, it's quite broad, and the language is not good for defendants. The easement indicates it shall run with the land, it shall bind and benefit the owners and occupiers of the benefited parcels, which Dawn is. There's no serious dispute here that she is an owner.
Well, I'm not sure that's true. I think Mr. Deegan is in fact disputing that. And
Judge,
Dawn wouldn't have had any right to use that easement on her own accord without Diane's permission, would she?
well, Judge, she does have a vested interest
As a remainderman.
And Judge, the distinction being made by the deed itself is owners and occupiers of the benefited parcels, their transferees, successors, and assigns. Arguably, that corresponds 2 different ways.
Well, How? I mean, a successor only occurs when, or assigns when there's a succession or an assignment. This Ladybird deed was an enhanced life estate that Miss Hayes had. And the case law is pretty clear that when there's a reserved life estate, the remainderman does not have a present possessory interest.
And I understand, Judge, but the easement itself doesn't say those with possessory interest. It says owners, transferees, successors, and assigns.
Okay, so was Miss Petraeus an owner?
I believe she was, Judge.
She didn't own the fee. She's a remainderman.
She does not own it in fee simple.
Okay, she's not an owner. Is she a transferee?
I would argue, Judge, that she is not a transferee for the reasons that
Okay, is she an assignee?
I think she could be an assignee, sure.
How can someone be an assignee prior to an assignment?
The assignment, Judge, you're talking, I'm sorry.
I've never heard of such a thing.
I'm not talking about a deeded assignment, so to speak. Ms. Hayes says in her deposition very clearly, of course my daughter would have the right and the ability to use my property. She grew up here. This is her home.
Okay.
I do think that the language of the easement, Judge, that it shall bind and benefit the owners and occupiers of benefited parcels, militates that direction. Furthermore, Judge, this argument that the defendants are making that, well, even if they had a right to walk it, that doesn't mean they had a right to document or to photograph or to defend their legal right. That's not what the easement says. The easement on its face says, as long as their use, the defendant's use, does not damage or interfere with the grantee's use.
Well, it does say it's got to be for ingress and egress.
And Judge, a walking path, that's what it's been recognized as.
So let me ask you, even assuming that that Miss Patrius had a right to use that easement, which I'm not sure she did, and even assuming that ingress and egress encompasses walking down there to check it out and take some pictures, why on God's green earth is Mr. Studer standing upon the landscape rocks, and why is that within the scope of an easement?
So Judge, the purpose of the easement, again on its face, is to provide a walking path to and from the beach.
Right, not to stand on the landscaping rocks. What's he doing up there?
He's documenting the obstruction of the path. That
You
is,
can't do that from the ground?
Judge, I think in hindsight, that's a fair argument. And I bet as he sits here today, Mr. Studer wishes he probably had not stepped on the rock. But that was the argument being made. And it's argued not just by Ms. Petraeus, by Ms. Hayes, by Mr. Rowe, by all of them, that this is the conduct, this is the obstruction being complained of.
Can I ask you, why is he out there at all? He's a zoning official. Even assuming that you're right about Ms. Kaufman's letter being wrong about that, and the affidavits or testimony from commissioners about individual members of the planning commission going out and investigating zoning issues. This wasn't a zoning issue, though, was it?
Judge, it's interesting you bring that up because this is not a question I don't think either of us had intended to ask Mr. Rowe, but it was a question he answered. This is not just like a hypothetical that it might be a zoning issue. Mr. Rowe said, yeah, that's what actually happened to me. I was building too close to the public easement and zoning came out. They didn't notify me in advance and they told me I was encroaching on that easement.
Yeah, that's some past thing. I'm talking about this complaint about that Miss Patrius or Miss Hayes even was having, that the Hineses were interfering with their easement rights. I get cases like that all the time.
Sure.
I kind of wish I didn't, to be honest. Those cases are very contentious usually, and they take a lot of court time. But they're not zoning questions, right? A dispute between two private property owners about whether one of them is interfering with the easement rights of the other. That's not the county's business.
Certainly, Judge, I think you're right that it is a private interest and suit could be brought that way in a private case. But the argument is that there's a number of actions Mr. Hines is taking. He builds a concrete parking pad actually over the easement. This is an allegation. I'm sorry, Judge. I'm not suggesting this is fact. This is an allegation being made. He builds a concrete parking pad over the easement. He puts in trees. He puts in, I think there's some talk about a tank. There's a number of easement tangential issues, which again, Mr. Rose saying, not just hypothetically, this is what happened to me. I did build too close to the easement and they told me, no, you can't do that. In his case, it was a zoning issue. Furthermore, Judge, I would indicate that if as Mr.
Well, you're again eliding what you're making an elision there, right?
I apologize, Judge, I don't know what that word means.
Well, look it up later.
Understood.
The fact that Mr. Hines had a past zoning issue does not answer my question. about whether this complaint about the easement interference was a zoning issue. And the fact that you won't answer that question, I think highlights my understanding that it's absolutely not a zoning issue.
Can I make two more brief points on that issue, Judge?
Absolutely.
As Mr. Studer and several other witnesses indicated during deposition, his role there is to investigate and document, not necessarily to take action.
Investigate and document what?
Right. He doesn't know until he goes.
So Mr. Studer is not like a deputized king of the county to
Correct.
enter onto private property whenever he willy-nilly wants.
Absolutely.
What right did he have to be on that person's private property, whether to investigate anything at all?
As to the easement, Judge, it would be Ms. Hayes and Ms. Petraeus asking him to be there.
All right. Anything else I need to know to understand your position?
Yes, Judge, if I might briefly cover a few issues.
Yep.
Judge, one of the first C-10 motions I ever argued, I was the filing insurance defense attorney. There's a judge not far from here that said something to the effect of, Mr. Kleigstad, you got 10 breaths to convince me there's no genuine issue of material fact. Every breath you take after 10 is your argument getting worse. If there's this much going on, then there probably is a genuine issue of material fact. The point nobody is discussing here, everybody seems to agree that Ms. Petraeus wanted John there. Now, I understand defendant is saying, well, not Ms. Hayes. Again, I would say that's a contested issue of fact. Ms. Hayes says she did want him there, and Ms. Petraeus says, my mom asked me to call him. A fact nobody is discussing is that John was never warned off of the property. There were no trespassing signs. Nobody asked him to leave. In fact, testimony.
Hang on. Does that mean he can go to my house tonight and walk around my backyard?
Of course not.
Of course not.
He admits that at the
Right.
deposition.
So they don't have to warn you off.
Oh, I agree, Judge. But we're
Okay,
talking
so what
about
point
this.
are you trying to make?
We're talking again about an easement which has a clear dominating estate. They're the ones who want him there, not the subservient estate. They don't ask him to leave, Judge. They ask him for his car.
All right, follow your own advice about the press.
Understood, Judge.
Can I briefly respond?
Hang on. No. He's not done. He's
Oh,
not done. I'm
wow.
sorry. You'll get rebuttal argument.
Judge, I do think that Reitz v. Tippett is a very important decision where the officer knew darn well that the premises were closed, that people were not welcome. The Court of Appeals in that case, Judge, was not deciding between trespasser and invitee, or trespasser or licensee, because there's an ocean of difference between those three things. The Court of Appeals was saying, is he an invitee or a licensee? And the analysis is, if his presence there is only loosely connected with his job duties, then he's a licensee. That's what they decided he was. If he's more like a garbage man, more like a meter reader, if his presence there is closely connected with his job duties, we're going to graduate him to invitee. That's the distinction the Court of Appeals is turning on. I think that's applicable here, Judge. All this is to say, Judge, that if this honorable court decided there was a genuine issue of material fact as to how closely John's presence there was related to his duties, or if this court felt that his presence there is only loosely related to his duties, it's not really a zoning issue, right? It's only loosely related to his function as a public servant. If that's the case, Judge, then the decision tree is between licensee and invitee.
What if it's not at all related to his duties as a zoning official?
We never felt that the case turned on that fact, Judge. And in fact, we were a little bit surprised that this has become the World War III issue. Maybe that's naivety on my part. We didn't necessarily see that coming, that defendants would say, no, he's gone rogue. This is not within the performance of his duties. Nevertheless, Judge, I would still point back to the fact that he's called there by the interested party, by the holders of the easement.
All right. Thank you. Anything else I need to know to understand?
Judge, I can tell the court is frustrated and
I'm not, hey, listen, I asked Mr. Deegan some tough questions. This is just what I do. I ask both sides tough questions because that's the only way I know when your argument breaks down.
absolutely, Judge.
So no, I'm not frustrated with you at all. Go ahead and make.
Oh, no, I didn't think so, Judge. I guess one point
Well,
on the
you said
notice.
so. You said so I thought you thought so.
I thought that the court was frustrated with the argument being made, not with counsel.
No, I'm not.
Judge, to the extent that they want to argue no notice, as you pointed out to Mr. Deegan in one of your tough questions, their argument proves too much. According to them, plaintiff can't miss the hazard. Well, if that's true, if plaintiff can't miss the hazard, then what do you mean you had no notice of it? You put it in. And Judge, that was a point that you made. But if we're construing facts in a light most favorable to the plaintiff, Ms. Petraeus says Mr. Heinz wasn't just aware that he placed these giant uneven boulders in the Hayes designated walking path, that he meant to do it, that it was his intention to render the walking path. That's what she says, Judge. In a light most favorable to the plaintiff, I think that helps us a lot. Judge, maybe just two more quick points. The argument being made here by defendants is the losing side of Smalley, right? What Mr. Deegan said was, well, if there was testimony that there was some ice in an alley and then a thing happened. Well, Judge, that is what happened. The testimony is that the landscaping holders are straddling the line between the easement and the public beach, and only in stepping over that easement or stepping off that hazard does injury occur. That's Smalley exactly, Judge. What the defendants in Smalley are arguing is this is pure speculation. We don't know what caused this. Was it black ice? Was it this? Was it that? And the court says no. In the light most favorable to the plaintiff, there are a lot of related but-for causes here, right? It could be that it concealed the curb. Could be that they had to step over the hazard, and that's what caused the fall. Could be that there's black ice from the melt-off. That is the case here, Judge. As you pointed out to Mr. Deegan, we've got three eyewitnesses, all of whom are saying, no, this is the spot, and it's caused by this treacherous walking path, right? The idea that Ms. Hayes never had an issue, Judge, she actually testified she wanted to put up signs. Walker beware, because you can't see the soft ground under this grass. Again, taking a light most favorable to the plaintiff, I think that is a genuine issue. Last point, Judge, and I'll hush. To the extent that defendants are trying to convince this honorable court to strictly construe the easement, say, Judge, this needs to be narrowly read, they're essentially asking this court to do the opposite of the C10 analysis. The C10 analysis says take the fact in the light most favorable to the plaintiff, giving the plaintiff the benefit of any reasonable doubt. That's not what they're asking you to do, Judge. They're asking you to hold us to the clean lines of that easement. That's just not consistent with the C10 analysis. Thank you, Judge.
All right, thank you, rebuttal.
Yes, Your Honor, briefly, I want to make one clarification. I do not represent an insurance company in this matter. I represent the defendant. It was noted that insurance defense, and I think that's inappropriate. But here we are on a C10 motion. We've already talked about C8 as to count two. And this motion has been pending. We've taken a lot of depositions. We have no issue of fact. The issues here as to the easement, there is no misinterpretation or other way to read that. The grantee shall use the easement only for the purpose of ingress and egress from the road to the beach, including such maintenance as the grantee deems necessary and appropriate. That's very clear language. And there is nothing in this easement that would provide for a rogue investigation by somebody who's been clearly not authorized to do this within the scope of his employment. So the claim fails. When they talk about, I guess I'm a little confused because they keep going that there's an issue of fact of whether it was on the public area, but there's no testimony that it was, and I think they conceded that it wasn't. But there's even, if there was an issue of fact of whether the accident happened on a public area, there's still no evidence that we caused some problem that caused an injury. And as to the testimony, because I want to be real clear here as to whether or not, they keep saying, I heard exactly this from plaintiff's counsel. She agreed she wanted him there. Their testimony is very specific. This is Mrs. Bodner. She said, I had said that we had an issue. He was interested in coming out, but she didn't contact him. He contacted her. It is undisputed that plaintiff never sought any invitation from my client at all. There was no notice. And if this case goes forward, I guess people then can come around on an easement or private property and have a look around and do some kind of investigation. I'm still not clear what the investigation was for, because those rocks were put there for erosion control, and there's no issue as to whether or not that violated the easement. So I asked that the case be dismissed, Your Honor.
All right, thank you.
Thank you.
Defendants filed a motion for summary disposition of this injury action. There's count one, premises liability, count two, negligence. The injury in this case happened when the plaintiff stepped off a landscaping rock on property owned by the defendants and within an easement area, and suffered an injury. And I don't think there's any genuine issue of material fact that the injury happened in the easement area, and that's what was pled. And given that, the count two clearly, the negligence count clearly does in fact sound in premises liability. So the negligence claim count two does not state a claim upon which relief can be granted. So I'm going to grant the defendant's motion for summary disposition of count two, the negligence count under MCR 2.116C8. Of course, the main issue is count one, the premises liability. One of the issues, I guess a threshold issue, is what was the duty owed, and was plaintiff a trespasser? Here, there are some facts that are clear, both factually and legally, that the plaintiff did not have permission from the property owner to be present on those premises. That owner would be Marvin and Carrie Hines. They're the fee owner of the property. He did not have their permission to be upon their property. Diane Hayes did have an easement to access a portion of that property for ingress and egress to a beach area. And it's also clear that Mr. Studer did not have, before the fact, permission from Ms. Hayes to be there. The fact that after the fact she said, you know, she didn't have a problem with that is not the same thing as permission to be there. Also, Dawn Patrius did not, as a matter of fact in law, have a present possessory interest. Legally, she was a remainder man under a ladybird deed, which reserved a life estate to Ms. Hayes. In fact, the ladybird deed, it's an enhanced life estate with power to convey. And the black letter law is clear that the remainder men do not have a present possessory interest. So Ms. Patrius did not own the property that Mr. Studer was on, and she didn't have a right to use the easement on her own accord. And even if she's considered to be a guest of Diane as the easement holder, she certainly did not have any authority to bring her own guests. So even if I read the easement to say you can bring a guest for ingress and egress, which I think would be a fairly common way to read an ingress egress easement, that means that Ms. Hayes could bring a guest. It doesn't mean the guest can bring a guest. Otherwise, an easement is not really limited. It's open to the public. So the plaintiff did not have any permission from anybody that had authority to be there. Plaintiff's use of the easement did exceed the terms of that easement. He was not there for ingress and egress. He was there to document some alleged violation. And I'm still not sure what exactly he's doing standing on the rocks. Certainly, standing on the landscaping rocks is not ingress and egress. And the court is still left with the question, why was the plaintiff investigating anything at all? It was none of his business. It was none of the county's business. The county attorney gave a letter opining that plaintiff did not have county authorization to be on the defendant's property. The plaintiff disputes this and has some testimony from one of the county commissioners saying that, you know, he disagrees with the county attorney's letter. But plaintiff has not shown that there was any pending application regarding these premises that was pending in front of the Planning Commission. There was nothing pending with the Planning Commission about this property. So therefore, it did not warrant any member of the Planning Commission to enter the property to evaluate some application. Rather, the dispute here was a private one about easement rights. And as I said, we get lots of lawsuits about that. It wasn't a matter of public access. It wasn't a zoning violation. Plaintiff has failed to point out a single provision of the zoning ordinance that the Hineses would have been violating by their alleged easement issues that Mr. Studer would have even been there investigating. I mean, we're a servient estate holder, that'd be the Hineses, where they are interfering, even assuming that they were interfering with Ms. Hayes' dominant estate holder's rights under a private easement. That's not a question for zoning. That's not a question for the county to decide. That's a question for a court of law to decide. Under plaintiff's theory, a citizen having a private land dispute with his neighbor can just have the government enter the neighbor's property without permission to document that. And that is most definitely not the law, and it doesn't give proper respect to private property rights. So on these facts and but under the law, I agree with the defendant. There's no genuine issue of material fact here. The plaintiff was in fact a trespasser on property owned by the Hineses. As such, defendant owed only a duty to refrain from willful and wanton misconduct. Plaintiff has failed to present any such evidence. Accordingly, plaintiff's motion for summary disposition count 1 is granted under MCR 2.116 C10. Count 2, as I said, is dismissed under C8. And Mr. Deegan, you can submit an order to that effect.
Thank you, Your Honor, I will.
All right, thank you, counsel.
Judge, one brief
Yes.
question. To
Yeah.
the extent that 2116 indicates that a party who is, loses a provider under a 2116 motion, may seek leave to amend their complaint. Might we have an opportunity to do that, Judge?
What's your amendment?
The only thing I can think of as I sit here, Judge, would be the willful and wanton nature or lack thereof.
You were on notice of that. I mean, no, and that would be so futile. There's no evidence on this record whatsoever of willful and wanton misconduct.
Thank you, Your Honor.
No, and that's really not something to bring up like after a ruling, just sort of on the fly, and I'll think of something. That's not how that works either.
Thank you, Judge.
All right, thank you.
Thank you. Have a nice day, Ron.
All right, each.